everyone, and welcome to our HIPAA Refresher and Update webinar. I am Katie Ilton, and I have Briar Andreessen, my colleague, with me.
Hello.
And if you are listening, you are likely listening for the purpose of getting training on HIPAA, and that is our goal over the next hour or so. Just a couple of housekeeping items. Our next webinar in October, which will be October 9th, it's a Wednesday at noon Central Time, David Glazer, Compliance Plan Extraordinaire, will be talking about compliance plans. He will be going over a little bit of the basics of what should be in a compliance plan and how to craft one, but he'll also be getting more in depth on where people go wrong with compliance plans, what the pitfalls are, and how to avoid them. So that will undoubtedly be a very valuable session on October 9th. So watch for an invite on that. Over the lunch hour, internet often gets bogged down, and so you might see a lag in your presentation, so be aware of that. Also, if your sound goes out, look at there's a communication from our IT person here, Robert, who will tell you what the number is that you should call in to hear the presentation if your sound goes out. Please submit questions that you might have about HIPAA and what we're saying as we go along, and we will leave some time at the end to go over some of those questions. We already have some from you, and that's great. All right, so let's get started. Just to give you a quick overview of what we're going to be talking about. As I said, this is a direct training webinar, so hopefully those of you out there are listening in order to get your refresher, your update on HIPAA basics and what's new. We're going to talk about the privacy rule mostly. We're going to talk a little bit about the security rule. As many of you know, there are changes to HIPAA that are going to be effective in just 12 days from now, so hence the timing of the webinar. Brian and I are going to talk a little bit about what we see organizations running into and common HIPAA pitfalls and how you might avoid those, and then have some time for your questions. This is just a key of those acronyms we're going to be using throughout our slides, so you can definitely reference back if you're not understanding what those are. So the context of having this webinar is, as I said, there are going to be HIPAA changes coming about in the next week and a half. They're going to be effective. There's been a lot of activity with the new rules. You've probably heard a lot about it at your organization. And covered entities are required to train employees and staff who deal with PHI. And so that is the reason we're here. And we're also here because we've seen a big uptick in enforcement from OCR, the Office of Civil Rights, which is the federal agency that's in charge of enforcing HIPAA. They were dormant for a little while, I suppose, for a few years back, and then they've been more active in recent years, and a letter from OCR is not an uncommon thing anymore. And a letter from OCR investigating a particular issue could be a big problem, and so that's the reason we're doing training, is to sort of ward off those things that may turn into big enforcement actions.
And this is Briar, and I'm just going to break in for 1 minute to just mention a couple of things that are related to that. We have seen more than one investigation from OCR where the investigation began because of a patient complaint that someone had viewed their information inappropriately, and it was a small issue. It was one patient and one person doing a bad thing at the covered entity, but the regional office investigating decided to take it to another level, and instead of just looking at the little privacy rule issue, they turned it into a gigantic security rule investigation. And I would say so far the IT department and the clinic manager have spent probably 100 or 150 hours dealing with this, trying to respond to OCR, trying to put in place what OCR seems to want but hasn't exactly said that they want. So even little issues can morph into big, gigantic headaches.
Just a disclaimer here that's actually an important one from us lawyers. We are going to be talking about HIPAA, which is a federal law, over the next hour. In many of your states, and we have people on from all over the country, you may have state laws that are privacy laws that are more protective of health information than HIPAA. So, for example, in your state, HIPAA might allow you to disclose information for treatment purposes outside your organization, But in your state, you might have a privacy law like we do in Minnesota that says you still need a consent from a patient in order to disclose info outside of your entity. So we can't obviously talk about all 50 states' laws in this setting, but it is absolutely important to know that there might be a state law out there that affects what you can do with PHI. To become familiar with that state law, know when to think about what the more protective law is, and also to incorporate those state laws into your policies and have your staff know about what they are.
And actually, we already received one very, very good question asking where is the best place to find state-specific HIPAA law, and wondering if the State Department of Health and Human Services would be a good option. And that is such a good question, and unfortunately there is not a very great answer to that. Some states have done a pretty good job of doing a preemption analysis. Some states haven't done anything. Occasionally you can find a good summary on a state website or Board of Medical Practice website. Sometimes even boards of dentistry or pharmacy will do that. But there is not one great place that has a summary of all the state laws, or even any state that I'm aware of that is real specific about what is and is not preempted. So I would say, you can contact lawyers, and we have some resources on those subjects, or a lawyer in your state may also have that information. But there, unfortunately, is not a clearinghouse of that info.
And as Briar mentioned, we have helped some clients outside of Minnesota, certainly, to know what those state laws are and incorporate them into their policies. So if it's something you're interested in exploring, let us know. Oh, we did just get a comment in that says to those general counsel who are on the phone, the General Counsel Roundtable website does have a 50-state survey. So we've never seen that, but that's great, and
yes,
check it out.
We won't officially give a recommendation for it because we haven't checked it out, but I think that is an excellent place to check the General Counsel Roundtable website.
All right. So just some important dates here. The big, most important date is in 12 days, September 23rd, is when everyone is supposed to have been trained on the new rules, and you're supposed to have updated policies and procedures. So that's why we are here on September 11th, helping you to do that. There is an exception to that compliance date for those of you who are on the phone who deal with business associate agreements. If you had updated your business associate agreement in around 2010, when there were some new changes, you actually have an extra year to get those agreements updated for the new rules. Most people are just practically speaking doing that now because it's just easier to do it all at once.
So I'm going to talk a little bit about the privacy rule basics, and I see the privacy rule as having three parts. One is the protection of PHI, protected health information. A second one is patient rights, what patients have a right to get when you have their PHI, and the breach notification provisions, which deal with what happens when you mess it up. So HIPAA specifically permits certain uses and disclosures. One is disclosure to the individual or that person's personal representative, which could be a parent or a guardian. HIPAA permits the use and disclosure of information for treatment and payment in what's called healthcare operations. And those are really anything that a healthcare organization needs to do to make its business function. So accounting services, legal services, quality assurance, that type of thing. It's all in this very big bucket of stuff called healthcare operations. HIPAA allows disclosures that are required by law, so where a state law or federal law makes you turn something over, HIPAA says that's okay. It allows disclosures to business associates as long as there's a business associate agreement in place, and Katie will talk a little bit about that. And you can always disclose it when it is specifically authorized by the patient. There are also a bunch of other permitted disclosures under HIPAA, and there are some big asterisks here because in all of these cases there may be a state law that affects how much you can do this. One is disclosure to family and friends, and we'll talk in a little bit more detail about that. You can disclose public health activities for those purposes to a public health authority that's investigating something to do with healthcare. You can report child abuse and neglect in every state. You can report to the FDA, report for law enforcement purposes, although that is an area where many states do have some specific provisions. You can report other abuse, neglect, and domestic violence situations beyond just child abuse. You can use the information or disclose it for research purposes, and there you do have to have either an authorization from the patient or an IRB that has given a waiver of the authorization requirement. You can disclose for workers' compensation purposes, and that's really state-specific, but the important thing with workers' comp is HIPAA says we don't have anything to do with workers' comp, so we purely defer to state law. Anything that state law says you can do with workers' comp information, you can do. You can also disclose for judicial and administrative proceedings, and there are several specific rules that go along with that, and so if you're ever in that type of situation, contact your privacy officer so you can talk through what needs to happen with that. And again, always remember that state law may be more protective and prevent you from giving the information unless there is a different kind of patient consent or authorization. So disclosure to family and friends, this one comes up fairly often and in some cases is kind of a gray area, but HIPAA tries to make it clear, and they say that if the person is present and they have the capacity, you can disclose PHI if the patient agrees or has previously agreed, or if they've had the chance to object and they don't, or if you can reasonably infer from the circumstances that the person doesn't object. So when a person brings somebody into the office with them during their exam, you can pretty much assume that that patient is okay with having information shared with whoever they brought into the room. If they ask you to talk to somebody on the phone for them while they're sitting there, that also is okay. HIPAA also says if the individual is not able to consent, for example, if it's an emergency situation or they don't have the capacity, they don't understand what is going on, if the professional determines that it's in the patient's best interest for this other person to know, you can disclose as long as the disclosure is only the stuff that is directly relevant to the person's involvement in care. So if somebody's incapacitated, you can give a friend or family member the information that would be necessary to take care of them, but you shouldn't be disclosing anything beyond that. You shouldn't be talking about their past history unless it has something to do with what this person is doing for the person this time around. Use your professional judgment to make reasonable inferences about things like picking up prescriptions or supplies or other similar forms of PHI. And for that last bullet point, always just, use best judgment and try to be reasonable. If you're ever suspicious about whether somebody really has the right to get this stuff, it's always okay to check in with the patient, assuming that the patient has the capacity to discuss it. But always okay to say, somebody is here saying that they want to pick up all your stuff. Are you okay with that? You can always do that, and better sometimes to do that than make a mistake and have a patient mad at you.
I'll just comment on the last bullet. I've had 2 instances where the patient had brought a significant other to a number of appointments and had allowed that person to hear all the information from the physician in the appointment, and even had permitted that person to contact the physician with regard to the patient. And then all of a sudden something in the relationship changed, and the patient didn't want the boyfriend or the significant other to hear any information anymore, but didn't communicate that to the physician, and so the physician continued on with talking with the significant other and resulted in a complaint and an OCR investigation. And so it's really just better to, when in doubt, or even when there might be a chance that someone does not want that person they brought along for so long to know anymore, just to check in with the patient. It's much saves a lot of time and money.
I would say maybe 40 to 50% of the stuff we deal with is a relationship gone wrong, and
Yes.
the result from that, whether it's snooping or some other bad thing. It just happens a lot, so try and be aware. Incidental disclosures are another type of disclosure that's permitted by HIPAA, and these are things where information is overheard or it's otherwise disclosed where it doesn't necessarily have to be, but it's allowed if it's a byproduct of another permissible use or disclosure under HIPAA. So you're allowed to talk to people for treatment purposes and for healthcare operations purpose. If somebody gets wind of that because you're doing that thing, it is okay, as long as you have reasonable safeguards to protect against impermissible uses and disclosures. And you should also use your minimum necessary policies and procedures, which Katie will talk about there. So, for example, healthcare staff can coordinate services at nursing stations. They can talk about patients. People can discuss a patient's condition over the phone with the patient or a provider or a family member, even if somebody standing in the waiting area might hear. A physician can discuss a patient's condition in a patient's semi-private room in the hospital. You can call names in a waiting room. You don't need to soundproof rooms, but the key here is be reasonable about it. And ask yourself, in your setting, in your particular setting, is it reasonable for certain things to be overheard? That may be much more likely in a dentist's office, for example, than in a place where somebody's receiving mental health treatment. Could you set up your process another way? Could you make sure that you're only using first or last names or something like that? Just be reasonable and try and limit the amount of information that is disclosed.
All right, so the minimum necessary concept it's a similar concept to what Briar was talking about with incidental disclosures, in that it's designed to keep disclosures to only the information that needs to be disclosed. So that's a simple rule. Don't give somebody information, or PHI, protected health information, that they don't need to do their job. It's a simple concept, but actually think this is overlooked quite a bit, and Briar will share anecdotally about how she's involved in an OCR investigation where there was an issue with the minimum necessary requirement. So it's really important to remember that if people don't need the patient's name or their diagnosis or whatever, then don't give it to them. And that applies internally as well. So staff who are doing claims processing might not need to know everything about the patient or that sort of thing. So keep it to a minimum, even internally, and also to when you're disclosing to your business associates. Your lawyer working on a deal where you're selling the practice doesn't need to know all of the names and social security numbers and diagnoses and everything of your patients where the accounts receivable are going to be sold to another practice. They just need to know only the information relevant to the business deal. So keep that in mind.
And if I could just fill in one more, just to clear up any confusion from what I just said, we have a question: is it permissible to call a patient in the waiting room using first and last name or by first name only? It is okay to use first and last name. I would never say, for example, that you should say Briar Andreessen here for your pap smear. You can say, Briar Andreessen, and that is okay, but you wouldn't want to say anything having to do with what they're there for. And if you're certainly free to use first or last, but first and last is not a wrong way to do it.
So there are a few instances where the minimum necessary standard doesn't apply. So if you're disclosing PHI to another healthcare provider for treatment purposes, you don't have to worry about limiting or stripping down the information to the bare minimum necessary in that instance. Obviously, you don't need to strip down information to the minimum necessary to a patient when you're disclosing to that patient upon their request. They have access to their entire record, and you don't have to strip the details. Disclosures that you make when the patient has given an authorization. If the patient has authorized the information be disclosed, you don't have to then think, okay, what does the person who's getting it really need? It's not applicable in that circumstance. And then also disclosures to public officials when you're required to do so by law, and that official says that the information they are requesting is the minimum required for what they're asking. So you don't have to substitute judgment there and say, well, I don't think you need this type of information, so I'm only going to give you X. That is one exception to the minimum necessary standard.
And Katie mentioned that a couple of things that we've seen with minimum necessary, it seems to have come up most often recently in business associate situations where something has gone wrong and OCR has gotten involved, and then they have looked deeper, as they want to do these days, and they said, oh, well, why is it a covered entity that you are transmitting all of this information to the business associate when they only needed certain subsets of that information? And it's a big problem when a vendor is doing something where they do use a lot of data, and you're doing big data dumps for revenue cycle management type things. That's a big one. Anything where you're giving a bunch of information to the business associate, always ask yourself, do we really need to be giving that much information? Do they even need patient names? Do they need service dates? Do they need diagnosis information? Do they really need access to the whole medical record? Those are questions that you should ask when you're disclosing to a business associate.
And speaking of business associates, this is a new area or an expanded area in the new HIPAA rules. I'm not going to spend a lot of time on it because business associates are usually dealt with by by one or two people at the organization who's in charge, who has the lucky job of being in charge of rounding up all the business associates and getting agreements with them. But you should be aware that of what a business associate is. And basically, a business associate is any entity or individual that creates, receives, maintains, or transmits PHI in performing a function on behalf of the covered entity. That definition has been expanded in the most recent rule. It includes health information organizations, e-prescribing gateways, data transmission services. So you may hear people saying, it seems like everyone is a business associate. And in some ways, it does seem like that's what OCR thinks. So if you have the thankless job at your organization of rounding up who all the business associates are, know that there is a revised definition and that it's broader now. So once you figured out who your business associates are, you have to do a few things. You have to absolutely have a business associate agreement with them. There are certain bells and whistles that go in the new business associate agreements. We have that. We have an updated template available. If you would like that, please contact us. If you are involved in negotiating with business associates, one powerful tool is to remind a business associate that they are now directly liable under the law if they screw up and not just contractually, so they had better sign the correct agreement because that's now on them and not just the covered entity. And then what else do you have to do with business associates? Well, you mostly have to have the agreement in place. You do not have to train your business associates. That's not required of the covered entity. The business associate agreement will explain what the business associate has to do with regard to PHI, and that's basically the control you have. Another new piece is that vendors of business associates of a covered entity are now considered part of the chain of people who need to have a special agreement in place if they're doing something with PHI. So if your business associate has a subcontractor, they will have agreed in their agreement with you to have an agreement with their subcontractor. And so that's now a new piece that's being rolled out. Basically, each agreement, everyone in the chain that deals with PHI is going to have an agreement.
And we did get a couple of questions on business associates. One of them is, one of our business associates has provided the covered entity with the business associate agreement to sign, designating the covered entity as the covered entity. Should we sign theirs in addition to the business associate agreement we sent to them, covering the same issues? And you really only want to have one business associate agreement. It's fine if a business associate provides a BAA to a covered entity, but my own preference is the covered entity should use its own business associate agreement because it knows what's in there. And if a business associate sends you one, you should say, well, let's look at ours and see if there's something that you need to change in our document.
We just had a clarification on who is a business associate. So it says, is the business associate. So we have to have a business associate agreement with our e-prescribing vendor. Yes, the e-prescribing gateways and vendors have now been defined by OCR as being business associates, and so you would need an agreement with them.
And we've seen some pushback from certain entities that don't want to sign a business associate agreement. And if it gets to be a very adversarial situation, it might be time to call in lawyers just to clarify with them, look, here's what the definition is. You are one whether you sign this or not, and if you don't sign it, you're violating the law. So,
surprisingly, you've seen a lot of pushback on business associates not wanting to sign agreements, and you should definitely stand your ground and say, this is the law now. It was the law before, but now it's even more the law, and these terms are required.
And one question too, who do I email if I'd like a copy of your new business associate agreement? That is on our website, and it is a free template version that we provide, so you can go to our website and check that out, and we can, I'm not sure if we've sent a link along with the webinar or not, but
you can certainly follow up with the link.
Yeah, everybody will get that link after the webinar.
Getting some more questions on business associates, but we want to get to the other items first, and we'll go back to them if we have time. De-identification this is not a new concept, and it hasn't really changed with the new rules, but the idea is basically that protected health information can be stripped to the extent that it is no longer considered protected health information. So, and you can do whatever you want with it if you meet the de-identification standard. So basically, it's de-identified if it doesn't identify an individual, and there's no reasonable basis by which somebody could identify the the individual. If you're going to de-identify information, there are two ways to do it. The first is to get a qualified statistical expert who will do something to the PHI that I can't quite explain. Or what we see more commonly is to use the de-identification safe harbor, if you will, where it is basically stripping the PHI of all of the bullets that are on the slide. And once you've done that and you feel pretty sure that you've done that, then it's no longer PHI, and you can do whatever you want with it. You'll see a lot of business associates ask to do this in their business associate agreements, and I guess the tip is to make sure that the agreement actually requires them to de-identify the information as required or as set forth in the HIPAA rules, so you know they're doing it properly.
And so now we'll talk a little bit about that second category of HIPAA stuff, the patient's rights. Patients have a bunch of rights under HIPAA that were new when HIPAA came out and that haven't changed too much until now. There are a few new provisions. So they have a right to access their information, right to request restrictions, right to amend, a right to an accounting of disclosures, and a right to request confidential communications. We're not going to talk too much about amendment or accounting. We'll just cover those very briefly, but one pretty important area is the patient's right to access their own information. If a patient asks to see their PHI, the covered entity has 30 days, it used to be 60, to provide access, and you can get a one-time 30-day extension, although OCR has said in the most recent preamble to the final rule that they don't expect that it should take 30 days most of the time, particularly with the new electronic health records. If it's faster now, then you should act more quickly and get patients their information sooner than that 30-day deadline. A new provision is if a person requests an electronic copy of their PHI that's maintained in what's called a designated record set, and essentially that's their medical record plus their billing information, essentially. You need to provide electronic access in the format requested by the person if it's readily producible, or if it is not, then in readable electronic format as agreed upon by the covered entity and the individual. And the agreed upon is kind of a goofy provision. So basically it means even if you've got a very difficult patient that is demanding, you need to come to some sort of agreement with that person about how you are going to get their information to them. And if the EHR, if your electronic record has links to images or other data, those images and data have to be included in the electronic copy provided to the individual. So how can you get people their information? You can send an unencrypted email. It is okay to do that. You should advise the person of the risk of doing that, and if the individual still chooses that method, you can go ahead and send it. You are not required to permit the patient to use their own portable external media. So if the patient says, oh, here you go, I brought my thumb drive, just put it all on here, you don't have to do that, and I would not recommend doing that because you don't want to introduce problems into your system with a virus or something else. But you also can't make the patient buy a thumb drive from you. You can't say, sure, we've got them for sale for $30, you can go ahead and buy this. You have to have a reasonable electronic format for them to use. So options might be, you can consider encrypted emails. Another popular option is a CD-ROM with PDFs of the information. And that generally is acceptable to most patients, and so hopefully that will work out for you as well. A goofy thing that is also new, if requested by an individual, a covered entity has to transmit PHI directly to another person that's designated by the individual. The only requirements are that they make that request in writing, that they sign it, and that they clearly identify the designated person and where to send the copy of the PHI. And the weird thing about it is I don't understand how that is different from an authorization situation. Generally, HIPAA says if a third party is going to get the information and it's not otherwise permitted under the rule, then you need an authorization. And that has always been what's happened in the past. Now they have said, well, if it's somebody requesting access, even if it's access by a third party, you need to transmit that information, and you shouldn't make them sign an authorization. Instead, they should just give you this in writing and signed and say, here, send it to my spouse, or send it to my lawyer, or send it to whoever. And if they do that, then you should send it to them. So it seems like kind of the only requirements or the only situations where authorization is really more appropriate would be in a research situation or maybe some lawsuit type of situations. It's really more limited now than it used to be. A big area of question is, what can we charge a person who is asking for their information? HIPAA says you can charge them a reasonable cost-based fee. They permit you to charge for labor costs for copying and for reasonable costs for electronic media, the actual costs. But it's not okay, they say, to charge a retrieval fee. So you can't just say, yeah, we charge $25 to go get that information. They say you can say, oh, well, it would take Briar 25 minutes to do that, and the cost of her time is X, and so we are going to charge that amount. But they say no retrieval fee. It's very important here to keep in mind state laws. A bunch of state laws have a maximum amount that you can charge, but you have to keep in mind what is reasonable. It may not be reasonable in this day and age to charge 25 cents a page or 75 cents a page or whatever state has their per page amount. If all you're doing is pressing a button and printing off a few pages, that might cost you a few cents. So keep in mind what's reasonable when you are setting those policies, and expect patients to complain about that.
Okay, the next patient right we're going to talk about is patient right to request restrictions. And I guess one thing that we haven't said about all of these patient rights is that hopefully you have at your organization a privacy officer, or you've decided who is going to be the central person who gets or who receives all of these requests. It's obviously better to have one person dealing with this than having everyone trying to implement the rules on their own. So if you have questions about any of these things, contact your privacy officer. Another right that patients have under HIPAA is to request certain types of restrictions on how their PHI may be used or disclosed. So they could say, I don't want you to send information to this other doctor who used to be involved in my treatment, or for example. The general rule is that a covered entity only has to agree to restrictions that are reasonable. You don't necessarily have to agree to the restrictions. Now, there is one exception that's new and that requires a covered entity to agree to, and that is when a patient requests that their information not be disclosed to their health plan, and they've paid in full with regard to the service that they don't want disclosed. So that is now the rule. You have to agree to that restriction if they paid in full. There's a couple exceptions to that. If you are required by law to make the disclosure to the health plan, then you can follow the law and you can go ahead and disclose it. If the patient doesn't pay in full for that service, then you can go ahead and disclose the information. You can, in order to make sure that you get paid, you can ask patients to pay up front for the service that they don't want disclosed. And you can require prepayment where pre-certification would otherwise be required. This is going to be, it'll be interesting to see how this plays out. And you might want to talk to your privacy officer and figure out within your organization how this will work, because some states' laws do not permit covered entities to bill health plan enrollees for covered services. And where that is the case, then this restriction requirement to follow the restriction would not apply, but you would have to consult with your lawyer and a privacy officer to figure out if that applies to you. So some other patient rights that are still in HIPAA, they haven't changed, but they're still rights of the patients and they're important to know about, are just here on this slide, and I'll kind of go through them relatively quickly. The first is the right to request confidential communication. So a patient may certainly ask the covered entity not to disclose, for example, not to leave messages on their home answering machine, or to call them at a certain number, or to send their bills or other correspondence to a certain address, because for confidentiality reasons or otherwise. You have to, if you're the covered entity, you must agree to those reasonable requests. Certainly you aren't required to go meet the patient on the corner of 7th and Broadway to hear the test results if that's what they want. That isn't really reasonable. But if they're reasonable, you can't ask why they're asking that, and you have to agree to them. The right to amendment. This is basically a patient has the opportunity to say to a covered entity, I don't think that the information in my record about me is correct. I would like you to amend it. The covered entity does not have to agree to amend the information. You do have to take the patient's request, you have to consider it, and you have to reply to them whether you decide to amend it or not. Certainly you don't have to amend it if the information is correct. There's a little bit of a process with the amendment. You should just know generally, you have to tell the patient if you are going to or if you're not going to amend the information. And then if you decide not to amend the information, the patient has to have an opportunity to object to that decision, and then to have that decision reviewed by another healthcare practitioner at the covered entity who is not involved in the first decision. And then if that decision is, if we decide still not to amend the information, then the patient has the opportunity to submit an objection statement or some statement that you will keep as part of the record, and that will be disclosed to the people that the patient asks you to disclose it to. So just know that with the amendment, there is a process that you have to follow, and talk with your privacy officer about making sure you follow that closely. The other right is that's still there is the right for a patient to get an accounting of disclosures. So basically, this is the patient saying, I want to know where all of my PHI has been, who has seen all of my PHI, who have you disclosed it to. So you will get I think people get these requests a lot. It's important to know what you actually have to do in response. The covered entity does have to account for certain disclosures, the date, the time, who received them, what was disclosed, etc. But there are many things for which you do not need to account. So any disclosure for treatment, payment, or healthcare operations, you don't have to keep a record of that. You don't have to keep a record of disclosures to the individual themselves. Anything that's incidental or authorized by the individual, you don't have to keep on your accounting. And then a couple more things in the bullets underneath. This might change. We had some commentary in 2010 from OCR about how they might change the accounting rule, but it hasn't yet. So important to understand what your obligations actually are and how to respond to patient requests. So I'm going to lump a couple topics into one slide because these are not, marketing, fundraising, and sale are not usually functions that people who are boots on the ground dealing with PHI every day typically handle. And so as a general rule, if your organization is doing marketing, fundraising, or selling PHI, you should have a policy and you should have a plan for how to do that. And just know that these are more complicated uses of PHI that have a lot more rules around them. So when you see this sort of thing, a red flag should raise, and you should know that this should be kind of centralized in your organization. I'll just say that marketing is basically communication to patients about products and things when you're receiving remuneration in return for that communication. And if that's happening, then you need to have an authorization from the patient. Sale of PHI is just what it sounds like. You're selling PHI. You absolutely have to have an authorization for that. Use of certain PHI for fundraising purposes. So this is if the covered entity or its foundation is trying to get people who were treated in their maybe a particular ward. They're trying to fundraise for that for a particular cause. You can use certain information for fundraising purposes, but again, tread carefully around this because there are very specific rules. We've talked a little bit about the HIPAA authorization, and just want to make sure we're clear on what it is. So as Breyer said, the HIPAA authorization is basically this fancy consent form that has a bunch of bells and whistles with certain language that you have to have in it to make sure it's valid, why the disclosure is being made, the purpose, the right to revoke, when the covered entity can condition treatment. So it's a document that has a lot of required language that permits a covered entity to disclose information, protected health information, in a way that isn't otherwise permitted by HIPAA. It's really important to know that a HIPAA authorization, or rather to know that just because someone has signed an acknowledgement that they received a notice of privacy practices doesn't mean that you've been authorized as a covered entity to do whatever you want with their protected health information. So I get this question a lot. Acknowledgement of notice of privacy practices is totally different than a HIPAA authorization. They're not the same thing.
So on to the security rule, which again is not something that most people who deal with PHI every day have to deal with very much, but the IT department at your facility or clinic, or the poor person that is in charge of IT, if you do not in fact have an IT department, does have to deal with the security rule quite a bit. And the security rule was ignored for a very long time because it was so loosey-goosey. It covers electronic PHI and says that it has to be protected, but it's very flexible, and there are not very many specific standards that have to be met. But OCR has really focused on this and has made security rule enforcement a much bigger deal. And so the most important thing for covered entities to do is to perform a security risk assessment and then implement protections for PHI based on that risk assessment. And that security risk assessment is supposed to look at every single area in your organization where you have electronic protected health information, how you receive it, how you send it out, and how you store it, and where you might have risks in doing that. And so once you find those problems, you find those holes, implement protections based on that. Encryption is not required for every covered entity, but reasonable security measures are. And in fact, OCR might decide that encryption is reasonable for your organization, and if something bad happens and you haven't encrypted, they're going to be mad at you for not doing it. So the upshot for security rule is, in addition to do your risk assessment, encrypt everything that you can. Laptops, phones, flash drives, iPads, desktops, really any place where information is stored that you can possibly encrypt it, do that. Use passwords as well. Have policies that say you may not share passwords with anybody. You want to know who has looked at your information. Do periodic security rule audits. So don't do one and then decide that you're done. Every time something in your security environment changes, OCR is going to want to see a new analysis of what has happened. And if something is not encrypted, then use extreme caution with it. If you have an unencrypted laptop, don't leave it in your car. Don't let somebody see you putting it into your car trunk. I would prefer not taking it out of the office at all, but I understand that sometimes that has to happen. But be very, very careful, because that is an area where there can be lots of problems.
Just a note on employee discipline under HIPAA. So the actual rule in HIPAA is very clear that a covered entity has to sanction employees who violate HIPAA in the same way that they handle other employee discipline issues. So basically, that's the government saying HIPAA is not to be taken lightly. Sanctions for using or disclosing PHI could include anything as serious as termination of employment, depending on how bad the violation was. So if your organization is stepping it up on disciplining people for HIPAA issues, the reason they're doing it is because they have to, and because an employee violation of HIPAA can really mushroom into a giant disaster. We'll talk a little bit later about this, but a lot of the complaints that start OCR investigations have to do with employees who are snooping in records, etc. So we've seen covered entity employers really cracking down, even more so recently. So let's talk a little bit about breaches. A breach, so this is the area of HIPAA where you have to actually tell people if you screwed up the privacy rule, the security rule. So before 2010, you could have violated HIPAA, but you didn't have a covered entity didn't have an obligation to tell the secretary of OCR or the patient that something got screwed up. As of 2010, and then just most recently with some changes, the covered entity now has an obligation to disclose to the government, to the individual, and then sometimes to the media or the press when there's been a HIPAA violation. And the reason that we care a lot about breaches is because breaches often lead to OCR investigations. That's how OCR gets their information about what's been going wrong, and that's probably, breaches are maybe one of the first places they're going to look to investigate people. So the hard part about breaches is figuring out what the heck a breach is. So the definition is somewhat helpful. Basically, a breach is any impermissible use or disclosure of unsecured PHI. So any privacy or security rule violation disclosure of PHI that's unsecured. So unsecured PHI is basically any hard copy or electronic PHI that has not been totally destroyed, if it's hard copy, to the extent that it's no longer readable, or if it's electronic, encrypted. So if it's neither one of those things, then it's unsecured PHI. And if you've impermissibly used or disclosed unsecured PHI, then you're basically presumed to be at the breach point, which is where you have to notify people. Under their new rules, there is, I guess, an out. If you're at the breach point where it's presumed to be a breach, you know it's unsecured, you know it was wrong disclosure. If you can show that there's a very low probability that the PHI has been compromised, then you might be able to get away with not calling it a breach anymore. There are a couple factors that OCR has given us to consider when we're figuring out whether there's a low probability that the PHI has been compromised. So kind of common sense things. What's the PHI that was involved? Is it really sensitive information? Does it have identifiers? How likely is it that someone can re-identify the individual based on what was disclosed? Who got the information? Was it just disclosed in a fax to another hospital? And if so, was the information involved not really that sensitive? Well, then maybe you're in a position to say it wasn't a breach because the person who received it was already bound by HIPAA. It's usually not going to be the case, but there might be a chance. Knowing whether the PHI that was disclosed was actually acquired or reviewed. This is where your computer forensics is going to come in. You might be able to demonstrate that an unencrypted machine was not actually accessed. That's great news if you can get there. And then I guess the extent to which the risk to the PHI has been mitigated. I'm not really sure what this means. It's hard to mitigate something once it's actually happened, but if you have something that you think would be creative there, go for it.
And I have likened this to Miley Cyrus at the VMAs, in that once you have seen it, it can't be unseen. So I think mitigation is really not much of a factor there.
Right. We are promised future guidance on this from OCR. We were promised future guidance back in 2010. I don't think we got it. So this is what we have to work with now. The breach analysis should really be done with your privacy officer and maybe with your lawyer, because I think it requires at least a conversation with another head in the game to figure out whether you're at the breach stage.
So if you do have a breach, here's what you have to do. You have to report to the individual, meaning you have to send them a letter saying, we are very sorry, here's what happened, your information, this is the information that was breached, and here's what we've done about it. You also have to notify the government. You have to tell OCR in an annual breach notification log, and this is a web-based thing that OCR has set up. So once a year, within 60 days of the end of the year, I believe it is, you go on their website, fill in all the information about what happened, and send that off. And you also have to notify the government immediately within the time period where you have to tell the individual if the breach involves more than 500 people in a geographic area. You also have to notify the media if the breach involves more than 500 people. So that is, if you're in a situation where you've got more than 500 people, prepare for an onslaught of garbage, because you're going to have OCR on you immediately, and also more than likely a state attorney general, lots of patient complaints, and it will be a big nightmare. But that is what you have to do. The obvious consequence of a breach, a big one, is bad press. But there can also be financial costs of breaches, even ones that are much less, many fewer than 500 people. You may still have to pay an attorney and some consultant fees to look at this. Particularly if laptops or jump drives are lost, you are probably going to have to do a computer forensic analysis to figure out what PHI was even lost in the first place. Extra staff time is almost a guarantee, and employee discipline and termination and HR costs. And potential penalties from the government, that is a consequence of a breach. Breach reporting is where the government gets a lot of its information on who has been non-compliant. The other way they get that information is from patients themselves who are complaining, and they might complain even if they haven't gotten a breach notification letter. They might suspect you're doing something wrong and just want to ring up OCR and let them know. But most of the time it's going to be you tattling on yourself or a patient tattling on you that's going to result in this OCR investigation.
So we've just listed a couple bullet points here of the common issues that we're seeing, at least anecdotally in our practices, that have come up with HIPAA. So by far, I think even now, the biggest issue is snooping employees. The reason this is an issue is because, and this typically comes up in a failed relationship context where somebody's mother-in-law works at the clinic and mother-in-law wanted to know more about the prenatal visit of daughter-in-law, and daughter-in-law didn't want that mother-in-law to know, and so daughter-in-law complains. And then the covered entity, has to notify the daughter-in-law that there was a breach, this person did actually snoop, and then what happens is typically, or a lot of times, the patient goes to OCR because they're still mad, and they explain to OCR that this happened, and I've seen within a week of a complaint, OCR sending a letter initiating investigation of the covered entity. And Breyer is involved in a giant disaster that started with a snooping employee.
Right, just a snooping employee who looked at, again, it was a girlfriend-boyfriend situation, looked at something, and then now it's changed into a security rule question. because maybe she used somebody else's password, but maybe not, and they've gone from there to examining the entity's entire security practice. I would say another piece of snooping employees is anytime that you are dealing with a famous person or a case that's been in the newspaper or on TV. If you're a hospital that is caring for a patient that's been in some well-publicized accident, I have at least one client that is, every time they see their hospital name mentioned in the newspaper, they do an audit on the patient's record to see who has been in that record, and almost inevitably there is at least one person who has a very, very questionable reason for being in there. So the upshot there is don't snoop. Don't be in the record unless you have to.
And know that covered entity employers are basically, in many cases, terminating employment upon learning of snooping. That's becoming more common and acceptable in the employment law context, I think. Hopefully you all heard the story about lost or stolen laptops, hard drives, flash drives, electronic PHI that's left out in the ether or somebody's stolen it. That's been a big issue for many people. There was a recent settlement with OCR and a covered entity where there was a firewall issue. There was it was discovered that the covered entity's firewall was basically not up to snuff or not maintained for a certain amount of time. I don't think there was a conclusion that anyone accessed any information, but it was available for people to access, and therefore OCR said that was a security rule breach, and they had to pay $400,000, and they're under this icky corrective action plan. So even if something happens and it's not clear that the information was accessed, there can still be bad things happening. And then, as Breyer said, patient complaints often turn into OCR security rule risk assessment analysis. So just because you think you might have one issue with the privacy rule doesn't mean that you aren't going to have questions about other parts of your compliance program. Okay, we have a boatload of questions. We want to try to get through as many as we can.
We will. Let's see here. Sorry, I'm trying to get these organized in a way that makes sense. We'll try and go with some of the earlier ones first.
Let me just say that while we're getting them organized, we have a bunch of questions about, do you have a policy on this, or do you have a business associate agreement on that, etc. We will send out a follow-up to everyone who's on the webinar with what we have available. So we have made our business associate template available for free for download from our website. We have for purchase, we have HIPAA policies and procedures that incorporate all of the new rules. We also have, so we have a federal law version, and we also have state law versions for Minnesota, Iowa, and Wisconsin. We also have notice of privacy practices, which is needed to be updated under the new HIPAA rules. And so that is all available. Those things are available for purchase on our website. Also, this webinar will be available to listen to for free on our SlideShare site. So we'll be sure to include that in our communication follow-up.
One question, if your clinic is not on an EMR and you use paper charts, are you required to provide an electronic copy? No, you are not.
Here, a question. We've just tried to have a vendor sign the business associate agreement, and they just don't return it. Other than discontinuing this vendor, do you have any other ideas? So a vendor, either won't return the agreement, or they're fighting about what should be in it, and what you say should be in it actually is what should be in it. Obviously, assessing the business relationship is something to do. If that's infeasible, Breyer was actually at a conference with OCR themselves in March, and somebody asked this very question: what do you do if a business associate with whom you have a relationship that you can't necessarily get out of won't sign the agreement? OCR actually said, do your best, document your efforts, and it might not be crazy to actually tell OCR that this is happening. So yeah, that's straight from the horse's mouth.
Right, OCR did say they would not come after the covered entity for not having a signed business associate agreement in place. Question on notices. Should the notice of privacy practices display the effective date March 26th, the effective date of the new rules, the compliance date of September 23rd, and the initial effective date of April 14th? Do they all need to be on the notice, or which one? I would probably say this notice is effective X date, which is whatever date you have your new one in place, which should not be later than September 23rd. You could certainly say it's effective April 14th and was revised September 2013, but you don't have to do that. One note there is you should say in your notice of privacy practices that the covered entity does reserve the right to change it.
Here, this question says, we provide services to independent physician groups who work at hospital facilities. And do we need a business associate agreement with the physician group and the hospital? So I'm not sure who the person is who's providing the service and what they're providing, but assuming that they're a business associate of a covered entity, you would definitely need a business associate agreement with the entity that has engaged you. So if if a physician group has engaged you, but then you need a business associate agreement with them. But if they're just working at a hospital, you would not need a business associate agreement with the hospital because the hospital hasn't engaged you in that respect. All right, shuffling here. A couple of questions that came in before the webinar we want to make sure we get to. General question about what are your suggestions for complying with HIPAA when you're faxing things? And this person is concerned about faxing to the correct recipient. What do you have to do? Do you actually have to call the recipient and make sure that you have the correct fax number? So this is, obviously the rule doesn't explain exactly what you do in faxing situations or in emailing situations. You want to do as much as you can to make sure you're sending it to the right recipient. As Breyer said in her very apropos example, once it's been disclosed to the wrong person, you can't take it back. So I think it's prudent to confirm the fax number.
Yeah, we did have one poor client who had sent information instead of to the physician office that they intended to send it to a local newspaper in a small town. So that was an unfortunate disclosure of information. There are a bunch of questions here about charging retrieval fees to other requesters like insurance companies and attorneys. Is that okay? Yes, the privacy rule says that reasonable charge applies only when the patient is requesting access. So the confusing part of that would be if the patient requests access but says send it to my attorney. Probably that would be the reasonable cost-based fee. But if the attorney is directly requesting it, then you would be able to charge whatever your other amount is, your non-reasonable amount.
This says, if we send out letters to patients in our database offering them things that they might be interested in having, for example, wellness, physical, performed by our physicians, is this considered marketing? So generally, communications to patients by covered entities about treatment, payment, or healthcare operations are not considered marketing. The exception is if the covered entity, receives some sort of payment from maybe a vendor or a medical device company or someone who's trying to get something out of the transaction. They pay for you to make that communication. If that is the case, then you need to get an authorization because that would be considered marketing.
Another one, under the treatment, payment, and healthcare operations exception or permission, the question is, do we have to include in our accounting of disclosures the office notes that we routinely send to a primary care doc? No, that would generally be considered treatment, and it would not have to be included in the accounting of disclosures.
Here's a really good question. I'm not sure there's a real answer to, or a straight answer to, but it says, what are offices doing when patients bring in their PHI on portable external media? How do offices get data off of the media without worrying about potential viruses, for example, potential viruses being introduced to their system? It's a good question. I haven't actually heard of this happening a lot, but it seems like maybe it is. I think it's certainly reasonable to say to a patient that you can't introduce foreign media into the clinic system. I think if the patient wants to give you information electronically, it's reasonable to ask them to provide it in a PDF, in an email, for example. Yeah,
and we have seen, in many cases, what a provider will do is take that paper stuff and they'll have it printed out and then they'll scan it into the electronic health record. That's always a little bit tricky because if it's hundreds of pages, you don't know what's in there and you don't know that anyone has ever looked at it before. So use some caution on that. We also got a question on giving an example of why a provider would be selling PHI, which is a really good question. There might be a case where somebody's selling a patient list to somebody else, and they would want you to get an authorization for that. That's not really ever going to happen. No patient is going to say, sure, go ahead and sell my information to whoever. So really, the provision is intended to prevent the sale of PHI and say, if you're going to be getting money for giving somebody PHI, you're going to have to make the patient specifically say that's okay.
Sometimes the sale thing comes up in a way that isn't obvious it's a sale. It's in the context of a larger arrangement that you have with maybe a e-prescribing vendor or someone who wants the data to do their own analysis of things or do their own research. And it might be buried in an agreement, and just be sure to watch and see if someone's getting PHI after the transaction is over and it doesn't seem right, then that might be considered a sale.
Right, and we did have a question about using collection agencies, and is that the sale of PHI if you're giving certain information to a collection agency to collect money that's owed? And no, that would be a business associate situation. Your collection agency is a business associate, and you're not selling them the PHI, you're giving them the PHI so that they can perform that collection service for you.
We got a couple of questions back on the patient's right to request a restriction and that new exception where you have to agree to it if they've paid in full for the service and they don't want you to disclose the information to their health plan. So I said that if the law requires you, the statute in your state requires you to disclose information to the health plan, then you can refuse the request from the patient. I think the trickier part is where the law doesn't say anything, but the health plan contract says you can't charge people for covered services. And there's not this HIPAA exception for when they request information not be sent to the health plan because they paid in full. This is a question that many people raised in the proposed rule that that OCR basically didn't really answer. They said, well, you have, at the time of the final rule, you have 180 days to comply. It's up to you to negotiate with your health plan in your contract what you're going to do about this. So if you haven't worked that out, I would try to work it out now with your health plan vendor, but there's not an answer, and honestly, it will be interesting to see how this plays out in the contracting context.
One here about if a physician practice office sends me a postcard telling me what new procedures he's doing, should that be authorized from the patient or does that fall under the limited PHI usage? I'm not sure that, and the question is that marketing or is it fundraising? And I don't think it would really be either one. If a physician office is just sending another office or another provider something that says, hey, guess what, I'm doing this procedure now, send me all your patients. It's marketing on behalf of that physician office, but it doesn't seem to me to be using any protected health information, unless the physician is saying, send all this information to your patients that have X, Y, and Z, then that is a different story. But even if you do that, if you're not getting paid from this other physician office, if you're just letting the patients know about another treatment option for them, that is not going to be considered marketing or fundraising. You can send it out as part of a treatment and care coordination.
Here's sort of a practical question. What would you suggest for the following? One staff member signs onto our schedule in the morning. Another staff member has access to the schedule throughout the day and are able to make changes to the schedule under the opening staff member's login. Is that okay? This is, I don't think there's a right or wrong answer for this specific scenario. Certainly the rules don't talk about this, but the rules do talk about the concept of making sure that only the people who need access to information have it. And with regard to logins and things, this can get kind of dicey. OCR has had guidance about people not using other people's logins. And so to the extent you can avoid it, I would try to. Particularly because this comes up in the snooping employee context where someone goes in under someone else's login. And it's really hard to explain, I think, to OCR where sometimes it's appropriate to use someone else's login and other times it's not. I think that you don't want to get into that conversation.
Yeah, if it's just purely a matter of convenience and it wouldn't actually be that hard to change, I would change that process probably. Please give an example of an exception when disclosure is required by law under patients' rights. That would be something where you're required by a rule or statute to disclose vital statistics information, for example, birth and death information. That's a disclosure required by law that is permitted by HIPAA.
Let's see here. Can you use PHI to send information regarding things like changes in CMS rules that might impact Medicare coverage? So I think this would fall under the group of communications where you're making it for treatment and for coverage and payment and healthcare operations purposes. So if you're making that communication, it's not marketing. It's an okay communication so long as you're not getting paid by an outside third party to do it.
A question on the HIPAA authorization and patients who are afraid to sign it because they feel they need a lawyer present. A lot of times they don't understand the condition treatment part. How can we make this easy for the patient to understand but still meet the requirements? An authorization does have very specific language about what has to be in there, including a provision that you have to tell the patient that the covered entity is not going to condition treatment or payment on whether or not the patient signs the authorization. And I think there are ways to word that properly or more simply for patients to just say, You do not have to sign this authorization. If you don't sign it, we will still treat you, and unless you're a payer, you don't really need to include that payment information in there. And that hopefully will get you where you need to go. To the extent you can simplify language and make it 5th grade reading level, please do that.
It's a question about our policies and procedures. Are your policies and procedures for sale detailed enough, or will the buyer have to recreate them? Our policies and procedures are obviously templates that we can't customize to everyone, not knowing who will be buying them. They contain all the required language. Certainly, with any template that you buy, you need to customize them for your organization. I think we actually do a pretty good job of getting people to where they need to be, such that they need to just tweak a little bit, but that's kind of how we've approached it.
And I think we've got time for just a few more because we're already over our time, but we'll try to answer the questions we haven't had time to get to offline. Can you talk about the requirements to post the notice of privacy practices? Do the postings have to be the entire notice of privacy practices, or can it be condensed? Unfortunately, you do need to post the whole thing. You're allowed to condense it and have kind of a cover page of the important stuff, but you do have to have the rest of it attached to that. So you have to post it in your place of business prominently. You're supposed to have it on your website, so if you do have a website, you need to have the notice posted on that as well. And then you have to have copies available for patients if they ask for it. And nobody really asks for it in my experience, but you have to have it in case they do. And you would have to give it to somebody at the first service delivery. It's a once-in-a-lifetime thing. You only have to give the notice to a patient one time and get the acknowledgement one time, but you do have to have it available in case anybody wants it.
Just maybe finish with, we've got a couple questions about this kind of weird distinction between the HIPAA authorization form and then the release of information form. So as Breyer said, the HIPAA authorization is different than a release of information or request for access form. HIPAA authorization has a number of sentences that it actually has to have in the form that say what the purpose of the disclosure is and when the covered entity can condition treatment on the person signing the authorization. And it's going to be used in marketing, research, fundraising, sale, other disclosures when HIPAA doesn't permit them otherwise. The release of information or the request for access form is when you have a patient who is requesting that they get their information, a copy from you, or that you send your copy to a third party. And in that case, the only thing that the writing has to have is the patient's name, what they want, and their signature. So we're past our time. We have a number of questions left that we will try to get to offline. Thank you for joining us, and we hope to see you or someone from your organization on October 9th when we're talking about compliance plans. Thank you.